everyone. I'm Kathleen Childs, and I'll be the host of today's webinar on mastering international contracts. I'd like to begin by stating that the comments you're about to hear from me and the other panelists are meant for general, informational purposes only. They do not constitute legal advice from EDC or the panelists. Always consult with your own legal counsel for legal advice. Now, if that sounds like some sort of legal caveat, it is. And if I sound like a lawyer, well, I am. In fact, I serve as legal counsel here at EDC. I have a professional obligation to tell you that as a lawyer for EDC, I have been hired to provide EDC and only EDC with legal advice. My comments today are for general informational purposes and are not to be construed as legal advice. Having said all that, I think that the next hour will be a great start to getting you in a legal headspace so you can anticipate potential issues in your international business dealings. And most importantly, so you can mitigate against them with well-planned contracts in place. Contracts are an inherent part of doing business. For example, you wouldn't dream of warehousing your inventory without insurance, but do you actually understand all of the legal terms in your policy? Most of the time, business owners don't find out what truly is and is not covered in any given contract until after a problem arises. And COVID has added another layer of complexity into the mix. So I'm going to start things off with a look at some of the best practices in setting up an international contract. Among other things, I'll talk about a few of the more important standard clauses, as well as how to avoid potential problems. Then Audrey will join the discussion and focus on using the right Incoterms in your contract. Audrey is a logistics and custom specialist at Orchard Custom Beauty in Toronto. Welcome to the program, Audrey.
Thank you for having me, Kathleen. I'm excited to be here.
It's our pleasure. Thanks so much for being here. If you're not sure what Incoterms are, take my word for it. They are extremely important. And Audrey's going to explain just how important with some examples from her own experience. And then next, we'll hear from John Drimmer, who's a partner at Paul Hastings in Washington, DC. John has more than 25 years of experience in resolving cross-border issues of every stripe. Hi, John. Thanks for taking the time out of your busy schedule to be with us today.
Thanks, Kathleen. Pleasure to be here. Look forward to chatting.
Happy to have you. John is going to provide some practical advice on what to do if your contract is delayed or canceled. And he's going to provide insights into some of the legal judgments that have been happening in the wake of COVID. I'll follow up by taking a few minutes to talk about some of the resources and trade partners you should tap into to help protect your company as you go global. And speaking of resources, I should mention that we will be referencing different ones throughout the program. You'll find links to those in the resource document, which you can download from the webinar console. And finally, we've saved the last 15 minutes of the program for our Q&A period. If you have questions you'd like to ask any one of our panelists, send them our way at any time using the question box in the webinar console. We will answer as many as we can in real time, and if any get missed, we will follow up with you after the program. Now, before we turn things over to Audrey to discuss the importance of using the right Incoterms in developing contracts, I'm going to take the next few minutes to cover some of the best practices to consider when setting up international contracts. So let's get started. First off, what is a contract? I think most of you know. It's an agreement between two or more parties that is enforceable by law. But how is a contract created? In common law, a contract is formed when someone makes an offer and another person accepts it and provides consideration like money as part of their acceptance. So let me ask you this. Is a purchase order a contract? Well, yes, under the right circumstances, it can be. Say you send a purchase order to a buyer with details on the quantity and price of product you're willing to sell them, and in response, that buyer sends you a payment. That could be a contract. The question to ask yourself is, did you mean for that purchase order to be a contract? Probably not. There are many important terms that you want to put in a contract, and a purchase order that has no additional terms is going to leave a lot of ambiguity, especially if something goes wrong. Now let's talk more specifically about some of the things that you need to look out for when you are contracting internationally. While there are a number of items, I'll touch on two big ones that you need to be thinking about. First off, language. Having your contract drawn up in English might be convenient for you, but the courts in some foreign markets will only accept contracts in their native language. If the foreign market requires that a contract be translated, you will likely need to get a certified translation. On top of that, what happens if the meaning of your contract is changed slightly from one language to the other? There have been court cases in Canada over the interpretation of the French versus English versions of a federal law. If it can happen here, it can happen in your contract too. That's why when a contract has been written in multiple languages, it's important to include a clause where you pick which language is going to take precedence over the other in the event of a conflict. And second, foreign laws. Unsurprisingly, each country has its own set of laws, which might require you to include certain provisions in your contract. So before finalizing any contract in a foreign jurisdiction, you'll want to have a good idea of any local legal requirements that you need to work into the contract. Basically, don't leave things to chance. Always check with a local lawyer. Now, there are also a lot of standard clauses that are going to appear in most contracts, and some are particularly important to pay attention to and include in an international contract. So let's look at a few of those now. First off, governing law. One of the most important considerations in any given contract is the legal jurisdiction. Your contract should set out which country's laws will govern in the event that you have to go to court over a dispute. So if you are a Canadian company selling to a Mexican buyer, you should agree on which legal system you're going to use in the event of a disagreement. And there may be times when you want to use neither your law nor the buyer's local laws. So for instance, if both sides feel that they don't understand the other side's laws, they may choose to use a law that's seen as more neutral or commonly used in international contracts, like the laws of the state of New York or the laws of England. Talk to your lawyer about what makes the most sense for you to use. Second, forum selection. This is the clause where you and the other party decide where you will go if you have a dispute with the buyer and want to resolve it. So whereas governing law, which I just talked about, is about choosing which country's legal system you will use to interpret the contract, the forum selection clause is about deciding where you will go to court if you have a dispute and you want it to be heard. If you are based in Canada, you will likely want to go to court in Canada, but there are a number of options you could choose. You could go to international arbitration. You could decide you are willing to go to court in the buyer's country, etc. Therefore, it's advisable to agree with the buyer upfront on how you will resolve disputes and where you can bring those disputes to be heard. Third, termination. Think about all the scenarios under which you would want to be able to cut and run from a contract and vice versa. Pay close attention to what the buyer asks for as reasons for being able to terminate the contract. You probably don't want them to be able to terminate for convenience or just because they feel like it. You want there to be a justifiable reason if they're going to terminate the contract. And if they are terminating, how many days notice do you need? 5, 10? These are all things that you need to think about with your lawyer and put into the contract. And finally, for now, I'll touch on damages and limitation of liability. You want to give thought to who owes the other party what if one side breaches the contract. You can try to cap your damages by including a limitation of liability. So one common example I see is some parties will say, our liability is capped at the amount that you, the buyer, paid for the goods and services. Now that's pretty great if you can get it. But note that in some countries, there are laws that reduce your ability to ask for this and might even override any contractual language you agree to. So again, here, a local lawyer can help you understand if this applies in your case. Pivoting now, I want to bring to your attention some of the potential problems that could arise. One example I see is people wanting a really short contract for the sake of keeping things quote unquote simple. I'm not suggesting you should be unnecessarily wordy and use lots of fancy Latin legal terms in your contract, but sometimes I see people wanting to use short contracts for the sake of not scaring off the other side. And there, it's really a case of short-term gain, long-term pain. A well-drafted contract that plans for worst-case scenarios is like a prenup. You hope that your relationship won't break down, but if it does, at least you have a roadmap on what happens if things go wrong. If your contract is too short and simple, you could end up spending way more money in litigation trying to sort out the terms you didn't draft for initially that could have been in there had you paid a lawyer to draft a more fulsome contract at the outset. And on that topic, another issue is wanting to avoid using lawyers altogether. You wouldn't go into a foreign country with no knowledge of local building codes and build a house there, right? So why would you be willing to go into a foreign legal system with no knowledge of the local laws and negotiate and sign a contract there without a professional's help? Using a local lawyer to negotiate an international contract has to be seen as an investment and not a place where you can save costs by doing it yourself. And then you have to factor in cultural considerations. So, of course, even before you start developing a contract, you have to go through the negotiation process with a new buyer. During these initial stages, it's important to understand that cultural considerations can play a key role. So, for example, in some cultures, they simply hate to say no. It would be considered the ultimate insult to say no to a prospective business partner during a meeting. But you might get the contract and come to realize that they have drafted a very firm no built into it. And finally, I'll highlight that balance of power can be an issue. If you're a small supplier to a large buyer and you really want that business as a means of gaining a foothold in a new market, then you may not have as much bargaining power, or rather ability to get the buyer to change the terms of their contract. When this happens, talk with your lawyer about other ways that you can mitigate the risk. So for example, if the buyer stands firm that they will not be required to pay if something happens to the shipment that neither you nor the buyer had control over, you may be able to get insurance that will cover you in the event that something goes wrong. Now, that's not to suggest that you shouldn't try to negotiate a contract that is more favorable to you. It's more to say that the better you can be at assessing your bargaining power, the more creative you can be at thinking through ways to mitigate your risk with your lawyer. Above all else, make sure to do your homework on the buyer because knowledge really is power. So when should you get a lawyer involved? The lawyer in me is always going to say right away, because I know from experience that heading off problems up front will save so much time, aggravation, and likely money in the end. But for many small businesses working with tight budgets, there are ways that you can do a bit of your own legwork up front. And this is not at all to replace legal advice, but rather to educate yourself about some of the issues beforehand. Having an understanding of these issues could minimize the back and forth you have with your counsel when it comes to drafting the contract, and in the end, that could save you time and money. If you want to have an idea of some of the standard clauses included in contracts, the International Chamber of Commerce has some samples you can look at on their website. I find it's a good way to become familiar with some of the standard language you'll see. But again, working with a lawyer should be seen as an investment. And once you have the main terms worked out with your lawyer, subsequent contracts will typically go faster. A good lawyer should be able to explain your contract in terms of risk, because at its fundamental, contracting is about allocating risk between two parties. So be sure that your lawyer explains exactly what each clause means and how it shifts the risk between the parties. And most importantly, it needs to reflect the level of risk that you're willing to take. When you're looking at different law firms to work with, make sure that the lawyer that oversees your file has the required level of scope and experience needed for your transaction. In addition to providing expert legal advice, ask them about practical risk management solutions and find out who else in their firm will be working on your transaction. Sure, a junior lawyer's hourly rate is a lot less, but so too is their level of experience. Ask for a fee estimate up front, and ideally even a cap on fees. You can ask your lawyer to advise you when their fees have reached, say, 50 or 80%, and that way you'll be able to gauge the time spent against remaining activities to be done. You can also ask to find out about any additional costs and fees and see their billing schedule. As a final thought from me, let's talk about some common contracting mistakes. In my experience, one of the most common mistakes I see in contracts is when parties don't pay enough attention to that boilerplate language on the back pages. They focus on product, price, and delivery. And of course, those are the most important considerations from a business perspective. But if things go south, it can be those pesky little clauses at the end of your contract that cause problems. Take the form selection clause I talked about earlier. You don't want to overlook that. There was even a newsworthy case a couple of years ago involving Uber and a Canadian Uber driver on this clause. The Uber driver in this case wanted to sue Uber for breach of contract, basically. But his employment contract with Uber said that all disputes had to be taken to arbitration in the Netherlands. Now, the fee alone, not including travel costs, to bring the dispute to the forum in the Netherlands was $14,500. In this case, the driver was able to fight that clause and won the right in Canada to have his case heard in Canada. But that in and of itself costs a lot of money to do. So don't skim over these sections of your contract, and you can ask your lawyer to help you understand what those are. And one other thing I see happening with alarming frequency is contracting using social media, like WhatsApp. To a certain extent, that is a reflection of the digital communications era in which we live. And from a business perspective, it might seem fast and efficient, at least in the beginning. But the devil is in the details. Just like in my purchase order example at the beginning, agreeing to the terms for purchase and sale via text leaves out a lot of important details. On top of that, courts aren't always willing to recognize these social media contracts as legal contracts in the sense of the law, meaning that the court might disagree that this is even a contract in the first place. Getting that kind of a contract recognized in a foreign jurisdiction can also be a nightmare. Well, that's it for me in terms of a very quick primer. Now let's bring Audrey into the conversation. How are you, Audrey?
Good, thank you.
We're happy to have you. And to get started, can you tell us a bit about Orchard Custom Beauty? Who are some of your clients? How many countries do you do business in? And what do you do there?
Sure. So I'm a logistics and custom specialist in-house at Orchard Custom Beauty. We're an award-winning business-to-business private labeling company. We specialize in cosmetics, beauty tools, bath accessories, and cut and sew items. We do business in about 16 different countries, either manufacturing or we're have our customers in those different countries as well, everywhere from China and Taiwan to Australia to Denmark to North America.
Suffice it to say, you're no stranger to doing business internationally.
No.
Well, I spoke a bit earlier about some of the clauses to keep in mind when developing international contracts, and I'd love to hear your take on it. So, in your experience, which ones can be difficult both at the negotiations and contract development stages, and do you have any advice?
For sure. I think in my experience, settling the legal jurisdiction is going to be key, especially when you're operating in court systems that you really don't understand that well, and you're going to be relying on, a foreign lawyer or agent. So settling that in somewhere that's either favorable to you or that is, as you mentioned earlier, neutral, I think is really key. And also the damages and liability, anything you can do to kind of keep those at a minimum or keep those friendly is great. Overall, I mean, I'm not the legal expert. That's what you and John are here for. But I would say, we think of these things as, Orchard has a sort of emphasis on building relationships with their vendors and customers. But ultimately, you want to have enough detachment to think of the worst case scenarios and be able to plan for those and prepare for those and have the uncomfortable conversations up front so that when something happens to go wrong, which inevitably one of your projects might be a disaster, then you have that framework and that preparation built in already. So it keeps things cordial, when you do run into trouble.
That's a really great way to put it, is you're really planning for the worst and hopefully it doesn't happen, but plan for the worst.
Yeah.
So what about Incoterms? For those in the audience who might not be familiar with Incoterms, can you explain what they are and why they're so important?
For sure. So Incoterms are the international commercial terms of sale. So they're really focused on, a widely used terms of sale and building a common language around that. They're clarifying the responsibility of buyers and sellers. And we sort of think of it in three key themes of the costs, the risks, and the obligations that is involved by each party. So they were started by the International Chamber of Commerce, the ICC, which is headquartered in Paris. The first 6 terms were introduced in 1936, so they've been around for a long time, whether everybody's been using them or not. And they are updated periodically, usually every decade, just to conform to all of the changing trade practices that we see. So the most recent update would have been Incoterms 2020.
Well, so speaking of that, you mentioned that the terms changed last year, and we actually did a webinar last February on the new Incoterms, which there's a link for in the resource document. Where else can our audience go to learn more about Incoterms?
Sure. So last February, that would have been my friend Emiliano. He's an Incoterms expert, and he was the one who encouraged me to go and take my Incoterms training. So the foundation source is the ICC. So you want to look to the International Chamber of Commerce, and they have Chamber of Commerces on sites all around the world. And of course, EDC is a fantastic resource.
Still on the topic of Incoterms, which one would you say is the most widely used, generally speaking? And are there ones that address disruptions to supply chains?
Absolutely. So there's 11 terms in Incoterms 2020. 7 of them relate to any mode of transport or multimodal modes of transport. So could be sea, rail, air, or truck. There's 4 that are specific to sea and inland only. And I would say the most commonly used, there's about 5 that are most commonly used. And it starts with Ex Works, which is having the goods ready at the factory. So the seller has the goods ready at the factory for pickup. And then it's the buyer's responsibility to collect those and move them through their value chain. FOB would be the next one, freight on board. So the seller's responsibility to deliver the goods to the port and pay the costs so that they're loaded onto the boat, and also are responsible for the export clearance. The next one would be FCA, which is free carrier alongside. We've started to see this used very commonly for air freight and also trucking. So the seller's responsibility is similar to FOB, but it's more specific to rail or air or a truck, to arrange the goods from their facility to a named place, and also is responsible for the export clearance. So that's become, like I say, a bit more common with air freight. The next one would be CIF, cost, insurance, and freight. This is one where the seller would arrange the goods to a foreign port, and then the buyer would collect and do the import clearance piece. A good example is people might not realize that you can't always act as a foreign importer or a non-resident importer in other countries. So specifically in my experience, we have customers in Mexico, and we make goods, say, in Taiwan or South Korea, and we're shipping to Mexico, but Orchard can't actually complete the import clearance in Mexico. So you could offer FOB, so the customer would pick up the goods themselves, but we offered CIF as sort of a value add. So we can get it to your port in Manzanillo, Mexico, and you can take care of the offloading, the clearance, and your own delivery to door. So it's sort of balancing out what the risk is to us, but also what a value add might be to the customer. And sort of the ultimate in taking care of everything is the DDP term, delivery duty paid. So you as the seller are responsible for the entire piece of moving the goods, all of the responsibilities, every single task, obligation, and the risk. So it's something to be very cognizant of what risk you're willing to take on. The second question you had was about, so during something like COVID-19, what your best terms, what your safest Incoterms might be. Mm-hmm. And Incoterms, it's really about the risk. So some of them have very little risk. So from the perspective of the seller, you want the buyer to do the most work and take on the most risk. So you're going to suggest terms like Ex Works or FOB, maybe FCA. If you're the buyer, you want the seller to take on the most risk. So you're going to want those terms like the CIF, the DAP, the DPU, and the DDP. Which is a whole lot of alphabet soup, but it's very important to understand what your risk is and who you're trying to get to take that risk.
That's so helpful, Audrey. Thank you for walking us through all those different terms. And you mentioned COVID. So as a bit of an aside there, how has your company been affected by COVID? And have you had to develop any workarounds?
Absolutely. I think, in general, we've been affected in very similar ways to everyone else. We're now working from home. We have a whole lot of hygiene and safety protocols that we maybe didn't have before. But I think key to this discussion is, what happened when some of our customers came to us and wanted to change up the contracts that we had in play. And we did have a couple of customers who, were, when you get into something like a pandemic and you're looking at your risk, you're primarily thinking of your cash flow and what's happening there. And so we did have a customer, can we cancel this order in May or June? And, our workaround was, built on relationships to say, maybe not cancel, but could you postpone, right? Instead of us delivering these goods in May, June, July, can we relook at this in the fall? So that was an option that worked on a couple of contracts. And when that didn't work and we had to cancel, we went to the supplier side and we said to our suppliers, look, like our customer wants to cancel, and of course you're going to want to charge the liability for what you've already put into it. Can we try and delay that? Maybe we will be able to sell this to a different customer. Maybe the customer will come back later in the year. So what we did was a lot of extension. Instead of outright cancellations or outright trying to pay, we tried to do delay tactics. And that seemed to work for us for quite a few of our jeopardized contracts.
Well, I'm happy to hear that. And I'm glad to see that you were able to use that kind of flexibility to really find solutions there. Well, Audrey, thanks again. We are so glad to hear that your company is doing so well, especially during these more difficult times. And thank you so much for all of your advice on Incoterms.
Thanks, Kathleen.
Thank you. So now let's turn to the topic of what to do if your contract is delayed or canceled. And to do that, I'm going to invite John into the discussion. Welcome, John.
Thanks, Kathleen.
Okay, so John, can you talk to us about your particular area of practice?
Yeah, for sure. So I work on complex cross-border legal challenges. Often it's on behalf of natural resource companies. I'm a former in-house counsel for Barrett Gold. But really, I work today across all different sectors. And the issues I deal with range from complex compliance solutions to investigations to litigation to enforcement actions. Certainly, always contracting is a big part of that. It's sort of the skeleton of a lot of commercial legal work, as you pointed out at the outset. But really, the common denominator for me is that the issues generally involve some kind of overseas dimension, and they're typically larger rather than some of the day-to-day matters that arise.
Well, we are so lucky to have someone with your level of experience here today. Now, COVID has caused a lot of issues with supply chains and contracts. So what are some of the different types of circumstances you've seen that have led to delays and cancellations?
Yeah, it's a wide range of issues, some of which, Kathleen, is predictable and some of which isn't so predictable. So, it's everything from delays in raw materials or component parts that are going into other parts or other products. Maybe they're not being delivered from overseas because factories or plants are closed. Maybe it's because ports have been shut down, either on the export, on the import side. Overground deliveries aren't really working terribly effectively. You certainly see contract delays and cancellations because of lack of anticipated customer demand. Sometimes it has to do with mandatory closures as well, particularly on local government regulations, local government decisions, emergency declarations. Look, you see plenty of contracts because of closures or shutdowns preventing things from ultimately being fulfilled. So on the downstream side, if you think about certain industries, entertainment, restaurants, hotels, travel, gyms, they've been decimated and they all have employees and suppliers. And then if you look on the other side, for the upstream situation in developing countries where a lot of supplies come from, it's totally chaotic. And it's a very difficult time overall for supply chain commerce. So you see a lot of different things that are ultimately impacting delays, cancellations, renegotiations, et cetera.
Yeah, to say that COVID has made things difficult for businesses really is an understatement. So now,
yeah, it made it difficult for everybody on everything.
Difficult for everybody. So can you talk to us then about the concepts of force majeure, frustration, and impossibility from a contracts perspective? And maybe you can start with some basic definitions.
Yeah, I'll talk about these because these are coming up, increasingly, as we all predicted they would, in the context of contract disputes as they relate to COVID impact. So all three of these, frustration, impossibility, force majeure, These are defenses as to why somebody should be excused from performance. They're similar concepts, but they're all a little bit different. So let me start with force majeure, which I know has been mentioned a lot, particularly by lawyers in the context of COVID. That is basically an act of God clause. It's an unforeseeable act. It's due to a circumstance. It's outside the control of either party. It typically will include things like wars, acts of terrorism, natural disasters, riots, strikes, that kind of thing. Every once in a while, you'll see clauses that are defined broadly to include health-related issues. Impossibility of performance is somewhat similar. Even if it's not specifically mentioned in a contract, it's a doctrine that is interpreted to belong. It's interpreted into every contract, regardless of whether it mentions the term. And like force majeure, it requires an act that's not the fault of either one of the parties to the contract. It has to occur after the contract is ultimately entered, has to have an element of unforeseeability, and it has to either destroy the subject matter of the contract or the means of performance, which comes up a lot on COVID. And frustration, that's the third doctrine. It doesn't come up as much as force majeure or impossibility, but basically the primary purpose of a party in entering the contract has to be frustrated, hence the name frustration of purpose. Has to happen, as with the others, through no fault of either party. It has to be an act or an event that goes against a basic assumption of the parties in making the contract. Not as widely used, as I say, as force majeure or impossibility, but it does come up sometimes. Last point I'll make on these, Kathleen, is they're interpreted very narrowly. Courts don't like to apply them. Performance of a contract isn't excused, where basically the impossibility or the frustration is caused by a financial hardship or by a difficulty that's indirect to the underlying unforeseen event. So it really has to be directly caused by the event. It's not just a link in the chain, and courts do interpret these terms very strictly.
I wish that my contracts professor in law school had explained those concepts as succinctly as you just did, because that is some complicated stuff that you really captured very well. Now, you talked about courts interpreting this strictly. Do different jurisdictions interpret a force majeure clause differently?
Yeah, they do. And what we're seeing, so there's been a fair amount of litigation, as you'll appreciate, in the wake of COVID. If you look at the litigation trackers that are online in the US, you see it's more than like 8,100 cases that have already been filed since COVID came into being. And courts in different jurisdictions will interpret force majeure clauses differently. Now, to be clear, sometimes force majeure clauses will have different terms. You talked about this at the outset in terms of contracting. Specific phrasings may ultimately be very different. So sometimes force majeure clauses will ultimately have epidemic and disease as one of the activities that's considered an act of God. But when it doesn't, and when it does, obviously the chances of success are a bit better than when it doesn't, as you'd imagine. But courts are then left, if it's not there, relying on natural disaster. And so that is typically included in most force majeure clauses, act of God and natural disaster. And how a court interprets natural disaster or act of God differs from jurisdiction to jurisdiction, and sometimes even from contract to contract. So you have a lot of different variation, particularly since natural disaster and act of God traditionally has been things like earthquakes and hurricanes and floods. And so the idea of an epidemic is a bit different from those kinds of natural disasters.
So then, if I'm hearing you correctly, COVID is probably not a force majeure event?
We're actually seeing different decisions come out of different courts on that. And again, some courts are saying this is an act of God, this is a natural disaster, even though it's a little bit atypical for the kinds of things that traditionally have been brought up and have succeeded as a force majeure defense. I think if you look at the span of cases, and to be clear, we're fairly early in the litigation cycle here. I mean, cases, as you know, take a fairly long time to work their way through the system. But some of the early decisions, more courts have said that it either doesn't fit the definition of a force majeure event, or the party raising the claim wasn't directly impacted by the force majeure event. It was more indirect, as I talked about before. You do have occasional decisions, though, where courts have said, yes, this is a force majeure event, even though epidemic or disease isn't defined in the contract, and it does excuse performance because of the direct impact.
So on that same topic, are there things we're learning in these court cases in terms of how to draft a force majeure clause to help situations like COVID in the future?
Oh yeah, well, for sure. So no question, I think force majeure clauses going forward are going to change and be explicit to include pandemics and include disease. And so to the extent that your form contract terms to date have with force majeure have not included epidemic, have not included disease, I think they're going to. Number one. Number two, traditionally force majeure clauses have always been considered what we would call boilerplate. Nobody pays attention to them except in the rarest of instances. I think they're going to be bulked up. I think you're going to see more bolding of language within force majeure clauses to emphasize the significance and potentially likelihood that one of these force majeure issues ultimately could come up. And certainly contracts that are being entered into right now not only are thinking about force majeure, but they're including other provisions that take into account the lack of predictability around supply chain commerce and direct commerce that does come from the COVID crisis. So we are seeing differences in a number of different respects when it comes to contract drafting today, and I'm sure we're going to see more of it going forward.
It's fascinating. So I want to pivot a bit now, and can you tell us what happens if your contract is delayed or canceled? Is there a kind of action plan in terms of response?
Yeah, there is, and really there are two primary components to it, and you heard Audrey talk about one of them, and that is figure out what's really going on. If they're at the supplier, talk to them. If you're the customer, and if you're the supplier, talk to your counterparty. What's the nature of the delay? What could be expected in terms of performance? Often it's a good idea to consult with your lawyer at that point to try to figure out what your relevant options are. But I got to tell you, courts are not that eager to hear companies fighting about contract disputes in the era of COVID. The general feeling is there are more important things than commercial disputes that, for the courts, for their families, for friends, for other people who are being affected. So courts are really quite sympathetic to people who claim to be affected by COVID these days, and an aggressive approach, rushing into court, filing a case, is typically not going to be the right answer. The right answer typically, and again, in consultation with your lawyer, you've got to talk to your lawyer about it to understand what your relevant options are, but try to work out what you and the counterparty really need. How much hardship is it really to you? How much hardship is it to them? What are the alternatives out there? Sometimes for one side or the other or both, it's a need versus want situation. What are the benefits of renegotiating, of restructuring versus canceling? It's something a good lawyer can ultimately help you work through. Can you deal maybe with less product, shorter timelines, longer timelines? Can you supplement with your whatever is missing with product from another supplier? So understanding the full set of operational options, something a good lawyer should be able to help you with, is really critical in assessing your overall set of choices here. But anyway, if you are going to plan to go to court, you got to be careful in your communications with the counterparty. Everything that you say is usable as potential evidence. Got to make sure your file is well kept in terms of agreements and drafts and the overall set of correspondence between the parties and deliveries and payments up to the point where there's a potential breach. Make sure you have, and your lawyer has, excuse me, a full set of agreements, full set of drafts, a full file. So you got to pull all that together. Be careful in any communications that you say. Consult with your lawyer. Think through your relevant options. Last point I'll make, and this is one that you guys talked about a little bit earlier, and that is a choice of law provision. Depending on what your contract says, sure, going to your regular lawyer, the lawyer who helped you with the contract, lawyer who normally does your litigation, certainly a good starting point, but bear in mind the place where the case may ultimately be litigated, where it may be tried, where it may occur, that may not be where you are and where you're used to doing business. So you may need to try to find a new local counsel, just depending on the choice of law issues or the nature of the legal issues that come up, or maybe the defenses that the other party brings up. Anyway, good place to start though is with your normal counsel who helped you with the contract and where you go for litigation.
Well, John, that was a broad question on my part, but some really practical advice there. So thank you for that and everything.
My pleasure. Thank you, Kathleen.
You've definitely given us lots to think about, but now let's look at some of the steps you can take right now to help protect your company as you go global. So think of global trade as a team sport. It's really important to get strong players on your side. To start, if you're not already in touch with the Canadian Trade Commissioner Service, or TCS, then that needs to be one of your first steps. They have over 1,000 trade experts in 160 markets around the world, and it is their job to help you do business in those markets. They have connections to in-market lawyers, accountants, and translators, and those connections can really help when building your contract terms. They also know suppliers and customers and can steer you towards those with good reputations. Plus, as representatives of the Government of Canada, they can also help sometimes if you get, they can help you get unstuck rather if your business deal gets stalled. The Canadian Chamber of Commerce is also a great resource, and they can help you further understand Incoterms. Add to them the Forum for International Trade Training. They are another great resource for Incoterms and all kinds of other trade training. Then, as far as lawyers go, my best advice in terms of choosing a lawyer is to find one before you actually need one. Ask for references from your network, and then do some no obligation, no fee initial discussions to figure out who you'd want in your corner. Same goes for the bank you deal with. Chances are you're going to need working capital to finance your operations while delivering on a new contract. So be sure to vet your lender beforehand. You want to know that they are willing to support your goal of expanding to new markets. And be aware of any restrictions and penalties in the contracts you sign with them. Now, in terms of anticipating some of the potential risks in doing business internationally, there are a few things you should understand. Contracts are an important way to anticipate, allocate, and mitigate risk, as we've discussed. But there are other things you can do as well. Now, keep in mind, for this next part, I'm not the expert in this field. This is where my business colleagues at EDC really shine. But getting paid by your foreign customer can sometimes be problematic, and having credit insurance to cover your receivables can help mitigate against that risk. Similarly, doing business in new markets typically means transactions in different currencies. Fluctuations can really ding your bottom line, but a foreign exchange facility guarantee can help plan for those eventualities. Then, as I mentioned earlier, lining up a lender that will help you in your export journey is important. EDC has a number of programs where we risk share with banks. So for example, if you need a loan to fulfill a new export contract, the Export Guarantee Program can help. Through it, EDC can guarantee the bank's loan to you without tying up your cash in collateral. Marine cargo insurance is another way that you can mitigate risk. And keep in mind that it is so important to do your due diligence with your suppliers and buyers ahead of time. Do you know other companies that do business with them? Can they vouch for them, etc.? And going back to what John said, in all cases, keep excellent records of all your transactions. It is so important to retain every piece of documentation, and of course, have them reviewed by experts. Because if you're called upon, you might be able to prove that a handshake or a WhatsApp agreement constituted a contract, but that's really a painful and expensive thing to do, and there's no guarantee that you're going to succeed. Finally, let me just say that EDC has some articles on the new Incoterms that you might find helpful. We've included links to those in the resource document, and of course, we have country risk information, our trade insights, and the Export Help Hub all ready to help you. So now it's time for the last part of today's webinar, the Q&A period. I can see from my monitor that we have already received a lot of questions, so thanks for that. Just give me a minute to scroll through some of them, and then I will start asking away. But there's still time, so if more questions come up, send them our way, and we'll try to get through all of them. So let's begin with our first question. I'll throw it to you, Audrey. Have you ever had to cancel a contract or had one canceled on you? And do you have advice on what happens in either scenario?
For sure. So we have had to cancel contracts with our suppliers, and generally it's been pretty straightforward. If there's, if it's early enough in the manufacturing stage, then we can just sort of pay for the cost of some of the materials. If it's a little further on into production, we have, a larger discussion around, what's already been produced. Do we have to pay the full amount of the contract? Or again, if we can try to be creative and sell the item to someone else, we might try that. We've had to deal with that quite a few times. And having a contract canceled on us, we've definitely had it for a variety of reasons. Not just in COVID, we've had it, before, whereas a customer either wants to cancel the whole thing because it doesn't fit in with what they're doing. Because we work a lot in cosmetics and beauty trends. So just if something isn't fitting or they, run into an issue, or if they want to reduce the amount. So sometimes we've had customers kind of get a little more optimistic and over order, and then we've had to sort of dial that back. But like I say, some of those relationships, and as John mentioned, some of the relationship building that you have kind of allows you to have, it's more of a conversation and discussion and less of a call up the lawyer and just, head to court. It's more of a negotiation process.
Oh, that's a great point. Thanks for that example. Now I'm going to throw one over to you, John. Here's a question we have. As an international consulting firm, we have had lots of problem with the liability and coverage in I think it's the limitation of liability and requirement to defend clause. So do you have any advice on how to mitigate against those risks without losing out to the contract?
Yeah, I mean, those really are risks that do come up fairly frequently on the consulting side. Normally, it's an individualized negotiation. Often companies will have set policies ahead of time in terms of what they are willing to do and what they aren't willing to do. My best advice is, number one, try to think through the issues well ahead of time, have those kinds of policies, have those kinds of standards, understand what your form contract provision ultimately ought to look like and really why it's there. When you do have people who are pushing back in the context of a negotiation, be mindful of what the risks and opportunities are every time you negotiate away a provision in your form contract that does create a potential risk. So make sure that ultimately the opportunity that you're getting is worth giving up what it is that you're losing in terms of contractual terms. And finally, again, this is one of those situations where a relationship with a lawyer who you've dealt with over time, who understands your business, understands the nature of the risks, they're going to be good barometers for being able to tell you whether a certain contract, a certain deal, a certain transaction presents risk that you really ought to be aware of in the context of your overall business dealings. The difference between a good lawyer and a really good lawyer, great lawyer, is a good lawyer can always explain to you what the law is, what the relevant risks are. A really good lawyer, great lawyer, can walk you through your relevant options, but also connect it to your larger business objectives, who you are as a company, what you're trying to achieve. And that's going to be true in this context as well.
Absolutely. One of the things when I'm advising my clients that I look at is you really want to think about, not short-term pain for long-term gain, especially if you're going to have a long-term relationship with this customer, then you want to make sure that you're contracting and starting off on the right foot. So don't necessarily give everything away at the outset just to get the business and then end up with a contract you don't like that sets the tone for your business relationship moving forward. Now, Audrey, a question about Incoterms. The question says, I understand and have self-studied Incoterms, but still have a hard time using them in language. So can you say, how do you use Incoterms? Do you just throw them in a sentence, those abbreviations?
Yes, intimidate your your other party by throwing a bunch of alphabet soup right at them. Yeah, I mean, there's certainly a lot of free information out there on Incoterms. Some of them, it is very, what's the best word for this? It's very wordy language. And sometimes it's the framework, it's very maybe legal or customs or that kind of language. It's not exactly layperson friendly. I think a next step maybe, and I would recommend this if you're in a position like me where you're in-house or you're the person running a value chain, or you want to be hired to run a value chain, you want to just take the official training from ICC through your local Chamber of Commerce, because they go through just the very in-depth, very detailed responsibilities of the seller and buyer in such great depth. And they also give you really fun scenarios so that you can practice who has what risk. Like if your forklift trashes a bunch of boxes while you're trying to load it onto a truck under X work terms, who's responsible? So, there's a lot of that scenario study that for me, really helped me when I was learning it, not just some of the language is a little bit dry for the average person. So yeah, the official training would be my best next step. And also just, practicing and figuring, trying to test yourself on some of those scenarios.
That's a great point. Yeah, whenever there's training, just avail yourself of that. So not everyone might know that that's out there.
Yeah, and it's not very expensive. I'm telling you, it's a value add. If you're in a position like mine, where you're the person who's kind of helping your company do this and helping plan for the risk, it's such a resume value add. And then on the flip side of that, if you're a very small business, and that's something that, it's low cost, not a big investment. And then you have that comfort level when you're building your contracts, and it kind of gives you knowledge to okay, now I know the Incoterms. What else? What do I not know? And then you can get your legal services and all of your other people, to help you with what you don't know. So it's just kind of foundational all around if you're going to consider doing international trade.
Yeah, absolutely. John, question for you that I think is getting at what we'd call in legal speak a battle of the forms scenario. We're a business and we sent a quotation and contract to a client and received a PO in return with a statement saying we confirm the contract. Should we be hassling that client to sign the actual contract we sent them, or is the statement in the PO enough?
Yeah, I mean, it really depends, Kathleen, as you know. I think that when you have a purchase order, sometimes purchase orders can reference larger terms and conditions and incorporate them by reference, in which case the purchase order and those terms and conditions are really the written part of the agreement. That's your agreement. And so it's definitely worth reading the fine print and making sure there isn't anything else that's incorporated by reference. But beyond that, assuming that there isn't, you really got to take a look at the nature of the contract and what the potential risks are. A small contract involving a fairly modest level of expectation, maybe the PO is enough. But I think for a more significant contract that may involve a longer period of performance, greater amounts at issue, greater volume of goods or services, you're probably going to want to have more provisions rather than less. And that could be anything from where a dispute or a choice of forum clause, where a dispute will be held, a choice of law clause, under whose laws will the contract ultimately be interpreted, all the way down. We talk about force majeure a fair amount in this conversation, what a force majeure clause might look like, particularly given all kinds of unpredictability vis-a-vis performance related to COVID. So answer is it sort of depends. But number one, bigger contracts, more important contracts, more terms are useful. Number two, when we look at purchase orders, always check and make sure to see what is being incorporated by reference into the contractual terms.
Absolutely. That's so key, is to pay attention to what could be incorporated by reference. Yeah, John, then we talked, that was a fairly narrow example, but if we look on a broader spectrum, when you're looking at international contracts, one question is, do you ever work with anti-corruption provisions?
Oh, well, sure. So that I spent an ungodly amount of time working on anti-corruption issues and anti-corruption provisions and other areas of international regulatory compliance as well. And you see a lot of different kinds of anti-corruption provisions. And again, it really is going to end up depending on whether you are the purchaser, whether you're providing it to somebody or somebody's providing it to you, and the nature of that relationship. For lower risk activities, a fairly simple few sentences is normally good enough, not only defining the laws, but also the specific behaviors, the specific activities that you expect are going to be followed. So it isn't just saying we agree to follow the CFPOA or the FCPA. It's we agree not to pay, promise, authorize, or give anything of value to a public official, etc. For more significant contracts, and for contracts where you might be dealing with a higher risk third party, often it's a good idea to include audit rights. potentially clawback rights for any amounts that you've paid that might be used for something improper. You can request those back. Termination provisions, so that a breach of the provision is ultimately going to be considered a material breach of the contract. A few other bells and whistles as well. So often, as part of form contracts, you'll see a baseline provision that's fairly brief, again, describing the conduct, not just by reference to law. For higher risk contracts, incorporating those additional terms and provisions is normally a good idea. Often that becomes a product of negotiation, as counterparties will sometimes push back. So that can be the product of negotiation for sure. Although always good to understand why they're pushing back, because anytime somebody pushes back on an anti-corruption clause or a part of an anti-corruption clause, that could signify something else. So always good to understand exactly their rationale for not wanting to sign on to a more robust anti-corruption provision.
Absolutely. So you've been doing so great at answering these broad questions. So I have one more for you.
Okay, fire away.
And then I'll switch back to Incoterms. How do you enforce a contract? So this, speaking for someone who doesn't have a ton of experience with this, do you need to go through a lawyer? I think you kind of touched on this when you said, what do you do if it's delayed or canceled? But how do you start if you want to enforce a contract?
Sure. I mean, look, the first thing you gotta look at is, the value that you're talking about here. I mean, is it really worth it to go and get into a protracted fight? Is it the kind of thing that you can try to work out in terms of, commercial provisions, hiring a lawyer, going to court, going through arbitration, going through the various dispute resolution processes? It's expensive, it's time consuming, it's operationally impactful. So really think about whether you want to go down that road. And my advice is always don't do it unless you feel like you need to. Try to work it out commercially. But if you do feel like you need to, having a dispute resolution clause in contract, as we talk about purchase orders versus longer contract terms, dispute resolution clauses are important. Sometimes they'll talk about arbitration. Sometimes they'll talk about mediation. Sometimes they'll talk about a dispute can be filed in a particular court in a particular jurisdiction. So got to check exactly what the dispute resolution clause looks like in any given contract. Personally, I generally suggest trying to have an arbitration clause, although arbitration is, not as efficient as people sometimes make it out to be. It is more efficient than regular litigation, than regular civil litigation. And particularly if you're dealing with foreign markets, it can be a little bit more predictable in terms of outcomes than trying to litigate in a foreign market. So I normally recommend thinking about an arbitration provision, but each contract is ultimately going to be different, and each preference of a party is ultimately going to be different too.
Absolutely. I have time for one more quick question. So Audrey, in 60 seconds or less, is the main difference between CFR and CIF terms and Incoterms who is responsible for insurance of the shipment?
Yes.
Yes. That was short and simple. Excellent. Thank you so much for that. Well, thank you again to both of you. That is it for today's program. I'd like to thank Audrey and John for being with us, and to you, our audience, for taking time out of your busy day to share the last hour with us. We'll be sending out a survey tomorrow morning requesting your feedback on this webinar. If you have time to respond, we'd really appreciate it. And let us know, please, any specific business challenges that you're facing right now with COVID. If you'd like to learn more about e-commerce in the retail sector, then please sign up for our next webinar, which will be held on February 25th. I hope you'll join us then. If you have any questions in the meantime, please give us a call at 1-800-229-0575 to speak with one of our trade advisors. Until next time.